Do you want to successfully complete the C233 Objective Assessment exam? Then you are in the right place. Our website provides a list of questions and answers for your success in the C233 OA exam for free. We understand that acing your OA exam can be quite challenging. That's why we provide completely free exam guides and practice questions for you. In this video, we will cover questions from business ethics, legal concepts, organizational behavior, management principles, and finance basics. So, let's get started. 1. An employer requires employees to sign a contract stating that they will not engage in union activities while employed. What type of agreement is this? A. Union shop contract. B. Yellow dog contract. C. Closed shop contract. D. Right to work agreement. Can you guess the answer? Correct answer, B. Yellow dog contract. Explanation: option B is correct because a yellow dog contract is an agreement where an employee promises not to join or engage in union activities as a condition of employment. These contracts are now illegal under federal labour law. Option A is incorrect because a union shop contract requires an employee to join the union within a certain period after being hired, which is the opposite of this scenario. Option C is incorrect because a closed shop contract requires a person to be a union member before they can even be hired, which is also generally illegal. Option D is incorrect because a right to work agreement is not a contract between an employer and employee, but rather a type of state law that prevents employers from requiring union membership as a condition of employment. 2. Which law requires employers to allow employees to continue their healthcare coverage for a period of time after they leave their job? A. Fair Labor Standards Act. B. Consolidated Omnibus Budget Reconciliation Act. C. Americans with Disabilities Act. D. Worker Adjustment and Retraining Notification Act. Do you know the answer? Correct answer, B. Consolidated Omnibus Budget Reconciliation Act. Explanation: option B is correct because the Consolidated Omnibus Budget Reconciliation Act, commonly known as COBRA, gives workers and their families who lose their health benefits the right to choose to continue group health benefits for limited periods under certain circumstances. Option A is incorrect because the Fair Labor Standards Act establishes minimum wage, overtime pay, record keeping, and youth employment standards. Option C is incorrect because the Americans with Disabilities Act prohibits discrimination against individuals with disabilities and requires reasonable accommodations. Option D is incorrect because the Worker Adjustment and Retraining Notification Act requires employers with 100 or more employees to provide advance notification of plant closings and mass layoffs. 3. Which term refers to a group's refusal to work with a business that is not directly involved in a labour dispute? A. Secondary boycott. B. Sympathy strike. C. Wildcat strike. D. Economic strike. Can you guess the answer? Correct answer, A. Secondary boycott. Explanation: option A is correct because a secondary boycott is an attempt by a union to pressure a neutral, secondary employer to stop doing business with another employer who is the primary target of the labour dispute. This is generally illegal. Option B is incorrect because a sympathy strike is when one union stops working in support of another union that is already on strike, but it is not a refusal to work with a third-party business. Option C is incorrect because a wildcat strike is a strike action taken by workers without the authorization of their union leaders. Option D is incorrect because an economic strike is a work stoppage to obtain economic concessions from the employer, such as higher wages or better benefits. 4. What legal document, required by the Immigration Reform and Control Act, is used to verify an employee's eligibility to work in the United States? A. W-2 form, B. I-9 form, C. 𝗬𝗢𝗨𝗟 form, D. SS5 form. What do you think is the answer? Correct answer, B. I-9 form. Explanation: option B is correct because under the Immigration Reform and Control Act, employers must use the I-9 form to verify the identity and employment authorization of every new employee hired after November 6, 1986. Option A is incorrect because a W-2 form is a tax form used to report an employee's annual wages and the amount of taxes withheld from their paycheck. Option C is incorrect because 𝗬𝗢𝗨 is an online system that compares information from an employee's Form I-9 to data from US government records. It is a system, not the initial required document itself. Option D is incorrect because the SS5 form is the application for a social security card. 5. Which act established workers' rights to form unions, collectively bargain, and engage in strikes? A. Fair Labour Standards Act, B. Employee Retirement Income Security Act, C. National Labour Relations Act, D. Worker Adjustment and Retraining Notification Act. What do you think is the answer? Correct answer, C. National Labour Relations Act. Explanation: option C is correct because the National Labour Relations Act, or NLRA, is a foundational statute of US labour law which guarantees the right of private sector employees to organise into trade unions, engage in collective bargaining, and take collective action such as strikes. Option A is incorrect because the Fair Labour Standards Act establishes standards for minimum wage and overtime pay. Option B is incorrect because the Employee Retirement Income Security Act sets minimum standards for most voluntarily established retirement and health plans in private industry. Option D is incorrect because the Worker Adjustment and Retraining Notification Act requires employers to provide notice of plant closings and mass layoffs. 6. Which of the following is a civil wrong that causes harm to another person and can lead to a lawsuit? A. Felony, B. Tort, C. Misdemeanor, D. Arbitration. Do you know the answer? Correct answer, B. Tort. Explanation: option B is correct because a tort is a civil wrong other than a breach of contract that causes a claimant to suffer loss or harm, resulting in legal liability for the person who commits the tortious act. Option A is incorrect because a felony is a serious crime in the common law tradition, usually punishable by imprisonment for more than a year or by death. Option C is incorrect because a misdemeanor is a criminal offence that is less serious than a felony and generally punishable by a fine or a short jail term. Option D is incorrect because arbitration is a method of resolving disputes outside of the courts, where parties refer their dispute to one or more neutral persons. 7. An employer implements a rule that only English can be spoken at work. Under what conditions is this rule allowed under Title VII? A. When English is the native language of the majority of employees. B. When the rule is necessary for business operations and is not discriminatory. C. When employees speak different languages. D. When employees voluntarily agree to the rule. Do you know the answer? Correct answer, B. When the rule is necessary for business operations and is not discriminatory. Explanation: option B is correct because the Equal Employment Opportunity Commission states that English-only rules are permissible only if they are necessary to ensure the safe or efficient operation of the employer's business. Option A is incorrect because the native language of the majority of employees does not legally justify an English-only rule. Option C is incorrect because the presence of different languages does not automatically make an English-only rule a business necessity. Option D is incorrect because employees voluntarily agreeing to the rule does not make it legal if it is otherwise discriminatory and not justified by business necessity. 8. Under the Age Discrimination in Employment Act, which defence can an employer use to justify an employment action that affects older workers? A. Bona fide occupational qualification. B. Business necessity. C. Reasonable factor, other than age. D. Undue hardship. Do you know the answer? Correct answer, C. Reasonable factor, other than age. Explanation. Option C is correct because the Age Discrimination in Employment Act, or ADIA, allows employers to defend an employment action if it is based on a reasonable factor other than age, known as RFOA. This means the decision was based on a legitimate, non-age-related business reason. Option A is incorrect because a bona fide occupational qualification is a very narrow defence that applies only when age is a genuine and essential requirement for a particular job, such as for pilots or bus drivers. Option B is incorrect because business necessity is a defence primarily used in cases of disparate impact under Title VII, not typically for age discrimination claims. Option D is incorrect because undue hardship is a defence an employer can use to show why a requested reasonable accommodation for a disability or religious belief cannot be provided. 9. Which type of pension plan provides employees with a fixed, predetermined benefit amount upon retirement? A. Defined benefit pension plan. B. Defined contribution pension plan. C. Profit sharing plan. D. 401k plan. What do you think is the answer? Correct answer, A. Defined benefit pension plan. Explanation. Option A is correct because a defined benefit plan promises a specified monthly benefit at retirement. The plan may state this promised benefit as an exact dollar amount, or it may calculate it through a plan formula that considers factors such as salary and years of service. Option B is incorrect because in a defined contribution plan, the employer and/or employee contribute a specific amount to the employee's individual account, but the final benefit amount is not guaranteed. Option C is incorrect because a profit-sharing plan is a type of defined contribution plan where the employer's contributions are discretionary and based on company profits. Option D is incorrect because a 401k plan is a popular type of defined contribution plan where employees can contribute pre-tax income, and the final payout depends on contributions and investment performance. 10. What action is prohibited by the Employee Polygraph Protection Act? A. Conducting drug tests on employees. B. Using polygraph tests for employment screening. C. Requiring employees to take intelligence tests. D. Performing medical exams before hiring. Can you guess the answer? Correct answer, B. Using polygraph tests for employment screening. Explanation. Option B is correct because the Employee Polygraph Protection Act of 1988 generally prevents most private employers from using lie detector tests, either for pre-employment screening or during the course of employment, with very limited exceptions. Option A is incorrect because drug testing is generally permitted, though it is regulated by various state and federal laws, but not by the Employee Polygraph Protection Act. Option C is incorrect because intelligence tests are not prohibited, as long as they are not used in a discriminatory manner. Option D is incorrect because pre-employment medical exams are regulated by the Americans with Disabilities Act, not the Employee Polygraph Protection Act, and are only permissible after a conditional offer of employment has been made. (11) Which of the following refers to a court-ordered remedy that prohibits a defendant from performing certain actions? A. Arbitration. B. Injunctive relief. C. Mediation. D. Settlement. Do you know the answer? Correct answer B. Injunctive relief. Explanation: Option B is correct because injunctive relief or an injunction is a court order that requires a party to do a specific act or refrain from doing a specific act. Option A is incorrect because arbitration is a process for resolving a dispute outside of court with a neutral third-party arbitrator. Option C is incorrect because mediation is a voluntary process where a neutral third party helps disputing parties reach a mutually agreeable resolution. Option D is incorrect because a settlement is an agreement reached between the parties in a lawsuit that resolves the dispute, avoiding a court judgment. 12. An employer seeks a waiver from an older worker that prevents them from making any future claims under the Age Discrimination in Employment Act. Which of the following is a requirement for this waiver to be valid? A. The employee must sign it within 7 days. B. The employee must be provided with 21 days to consider it. C. The waiver must be notarized. D. The waiver must not include any financial compensation. Can you guess the answer? Correct answer B. The employee must be provided with 21 days to consider it. Explanation: Option B is correct because the Older Workers Benefit Protection Act, which amends the Age Discrimination in Employment Act, specifies that for a waiver of rights to be knowing and voluntary, the individual must be given at least 21 days to consider the agreement. Option A is incorrect because the law requires a consideration period of at least 21 days and also provides a 7-day period after signing during which the employee can revoke the agreement. Option C is incorrect because notarization is not a federal requirement for the validity of an ADA waiver. Option D is incorrect because for a waiver to be valid, it must be in exchange for consideration, which is something of value such as financial compensation, to which the employee is not already entitled. 13. What is the purpose of the Rehabilitation Act of 1973? A. To protect older workers from discrimination. B. To prevent discrimination against individuals with disabilities. C. To establish minimum wage and overtime standards. D. To regulate collective bargaining agreements. Do you know the answer? Correct answer B. To prevent discrimination against individuals with disabilities. Explanation: Option B is correct because the Rehabilitation Act of 1973 was a precursor to the Americans with Disabilities Act and prohibits discrimination on the basis of disability in programs conducted by federal agencies, in programs receiving federal financial assistance, in federal employment, and in the employment practices of federal contractors. Option A is incorrect because protecting older workers is the purpose of the Age Discrimination in Employment Act. Option C is incorrect because establishing wage and hour standards is the purpose of the Fair Labor Standards Act. Option D is incorrect because regulating collective bargaining is a primary function of the National Labour Relations Act. 14. Which term describes the conveying of an employee's rights to benefits or contributions after a certain amount of time with the employer? A. vicarious liability, B. vesting, C. employee tenure, D. employment at will. Can you guess the answer? Correct answer, B. vesting. Explanation: option B is correct because vesting is the process by which an employee accrues non-forfeitable rights over employer-provided stock options or employer contributions to a retirement plan. The employee gains full ownership after a specified period of service. Option A is incorrect because vicarious liability is a legal doctrine where one party is held responsible for the actions or omissions of another party, such as an employer being liable for an employee's actions. Option C is incorrect because employee tenure refers to the length of time an employee has worked for an employer, but it is not the legal term for gaining rights to benefits. Option D is incorrect because employment at will is a doctrine that states an employment relationship can be terminated by either the employer or the employee at any time, for any reason or for no reason at all, as long as it's not an illegal reason. 15. What does the term constructive discharge refer to in employment law? A. When an employee is terminated for just cause. B. When an employer makes working conditions intolerable, forcing the employee to resign. C. When an employee is terminated without cause. D. When an employee resigns voluntarily. Can you guess the answer? Correct answer, B. When an employer makes working conditions intolerable, forcing the employee to resign. Explanation: option B is correct because constructive discharge occurs when an employee's resignation is not truly voluntary, but is prompted by the employer creating working conditions so difficult or unpleasant that a reasonable person in the employee's position would feel compelled to resign. Option A is incorrect because termination for just cause means the employer had a valid, supportable reason for firing the employee. Option C is incorrect because termination without cause is when an employee is let go for reasons not related to misconduct, such as a layoff, and is distinct from constructive discharge. Option D is incorrect because a voluntary resignation implies the employee chose to leave without being forced by intolerable conditions. 16. What type of strike occurs when employees refuse to work because of unsafe working conditions or labour law violations? A. Economic strike. B. Sympathy strike. C. Unfair labour practices strike. D. Wildcat strike. What do you think is the answer? Correct answer, C. Unfair labour practices strike. Explanation: option C is correct because an unfair labour practices, or ULP strike, is initiated in response to an employer's actions that violate labour laws, such as refusing to bargain in good faith or retaliating against union activities. This can include protesting unsafe conditions. Option A is incorrect because an economic strike is focused on obtaining better economic terms, such as higher wages, shorter hours or improved working conditions, not in response to a legal violation. Option B is incorrect because a sympathy strike is a work stoppage by one union to support another union's strike. Option D is incorrect because a wildcat strike is a strike not authorised by the union, regardless of the reason for the strike. 17. Which federal law prevents employers from retaliating against employees who report violations of workplace safety regulations? A. Fair Labour Standards Act. B. Occupational Safety and Health Act. C. Employee Polygraph Protection Act. D. Equal Pay Act. What do you think is the answer? Correct answer, B. Occupational Safety and the Health Act. Explanation: Option B is correct because the Occupational Safety and Health Act, or OSHA, includes a whistleblower protection provision that prohibits employers from retaliating against employees for exercising their rights under the Act, including filing a complaint or reporting an injury. Option A is incorrect because the Fair Labor Standards Act deals with wage and hour laws, not workplace safety retaliation. Option C is incorrect because the Employee Polygraph Protection Act deals with the use of lie detectors in employment. Option D is incorrect because the Equal Pay Act prohibits wage discrimination between men and women performing substantially equal work. 18. Which act requires employers to offer continued health insurance benefits to employees who have been terminated or otherwise left their job? A. Americans with Disabilities Act. B. Consolidated Omnibus Budget Reconciliation Act. C. Worker Adjustment and Retraining Notification Act. D. Family and Medical Leave Act. Can you guess the answer? Correct answer. B. Consolidated Omnibus Budget Reconciliation Act. Explanation. Option B is correct because the Consolidated Omnibus Budget Reconciliation Act, known as COBRA, mandates that employers with 20 or more employees offer a temporary continuation of group health coverage to employees and their families after events like job loss or reduction in hours. Option A is incorrect because the Americans with Disabilities Act focuses on preventing discrimination against individuals with disabilities. Option C is incorrect because the Worker Adjustment and Retraining Notification Act requires employers to provide advance notice of mass layoffs. Option D is incorrect because the Family and Medical Leave Act provides for job-protected leave for family and medical reasons, but it does not govern post-employment health benefits. 19. Which of the following laws provides whistleblower protection to employees who report illegal activities in government contracting? A. Family and Medical Leave Act. B. False Claims Act. C. Employee Retirement Income Security Act. D. Age Discrimination in Employment Act. What do you think is the answer? Correct answer. B. False Claims Act. Explanation. Option B is correct because the False Claims Act contains a qui tam provision that allows private citizens to file lawsuits on behalf of the government against organisations that have defrauded the government. It includes strong whistleblower protections against employer retaliation. Option A is incorrect because the Family and Medical Leave Act provides for job-protected leave for family and medical reasons. Option C is incorrect because the Employee Retirement Income Security Act sets standards for retirement and health benefit plans. Option D is incorrect because the Age Discrimination in Employment Act protects older workers from discrimination. 20. What is the primary purpose of the Employee Retirement Income Security Act? A. To ensure fair labour practices. B. To protect worker pension plans and benefits. C. To regulate child labour laws. D. To provide protections for whistleblowers. Do you know the answer? Correct answer. B. To protect worker pension plans and benefits. Explanation. Option B is correct because the Employee Retirement Income Security Act, or ERISA, is a federal law that sets minimum standards for most voluntarily established retirement and health plans in private industry to provide protection for individuals in these plans. Option A is incorrect because ensuring fair labour practices related to unionisation and collective bargaining is the primary role of the National Labour Relations Act. Option C is incorrect because regulating child labour is a key component of the Fair Labour Standards Act. Option D is incorrect because while some laws like the False Claims Act and OSHA provide whistleblower protections, it is not the primary purpose of ERISA. 21. Which act prohibits discrimination against employees or applicants based on national origin or citizenship status? A. Fair Labor Standards Act. B. Immigration Reform and Control Act. C. National Labour Relations Act. D. Family and Medical Leave Act. Do you know the answer? Correct answer, B. Immigration Reform and Control Act. Explanation. Option B is correct because the Immigration Reform and Control Act, or IRCA, includes an anti-discrimination provision that prohibits employers from discriminating on the basis of national origin or citizenship status, while also making it illegal to knowingly hire undocumented workers. Option A is incorrect because the Fair Labor Standards Act deals with wage and hour laws. Option C is incorrect because the National Labour Relations Act protects the rights of employees to engage in collective bargaining and union activities. Option D is incorrect because the Family and Medical Leave Act provides for job-protected leave for specific family and medical reasons. 22. Under which act are federal contractors required to take affirmative action to employ veterans? A. Family and Medical Leave Act. B. Vietnam-era Veterans Readjustment Assistance Act. C. Employee Retirement Income Security Act. D. National Labour Relations Act. Do you know the answer? Correct answer, B. Vietnam-era Veterans Readjustment Assistance Act. Explanation. Option B is correct because the Vietnam-era Veterans Readjustment Assistance Act, known as VEVRA, requires federal contractors and subcontractors to take affirmative action to recruit, hire, promote, and retain protected veterans. Option A is incorrect because the Family and Medical Leave Act provides for unpaid, job-protected leave. Option C is incorrect because the Employee Retirement Income Security Act regulates employee benefit plans. Option D is incorrect because the National Labour Relations Act governs relations between unions and employers in the private sector. 23. Which of the following terms refers to an employer's action of treating an employee unfairly due to their race, gender, or other protected characteristic? A. Bona fide occupational qualification. B. Disparate impact. C. Disparate treatment. D. Business necessity. Do you know the answer? Correct answer, C. Disparate treatment. Explanation. Option C is correct because disparate treatment is a form of intentional discrimination, where an employer purposefully treats an individual or group of individuals differently because of their protected characteristic. Option A is incorrect because a bona fide occupational qualification is a defence for discriminatory practices, not the act of discrimination itself. Option B is incorrect because disparate impact refers to policies or practices that are neutral on their face, but have a disproportionately adverse effect on a protected group, and it does not require intent to discriminate. Option D is incorrect because business necessity is a legal defence an employer can use to justify a practice that has a disparate impact. 24. What is the primary purpose of the Fair Credit Reporting Act in employment? A. To regulate medical testing for employees. B. To provide whistleblower protections. C. To protect the privacy of employees' credit information during employment screening. D. To prevent discrimination against employees based on their credit history. Do you know the answer? Correct answer C. To protect the privacy of employees' credit information during employment screening. Explanation. Option C is correct because the Fair Credit Reporting Act, or FCRA, governs the collection and use of consumer information, including credit reports for employment purposes. It requires employers to obtain consent and follow strict procedures to ensure privacy and accuracy. Option A is incorrect because medical testing is primarily regulated by the Americans with Disabilities Act. Option B is incorrect because whistleblower protections are covered by various specific laws like OSHA and the False Claims Act, not the FCRA. Option D is incorrect because while the FCRA provides procedural protections, it does not outright prohibit employers from using credit history in decisions. Rather, it regulates how they can access and use that information. 25. Under the Occupational Safety and Health Act, what must an employer do when an employee reports unsafe working conditions? A. Dismiss the complaint. B. File a report with the National Labour Relations Board. C. Investigate the issue and take corrective action, if necessary. D. Conduct a safety inspection within 60 days. Do you know the answer? Correct answer, C. Investigate the issue and take corrective action if necessary. Explanation. Option C is correct because the Occupational Safety and Health Act, or OSHA, requires employers to provide a workplace free from recognised hazards. When a hazard is reported, the employer has a duty to investigate and abate it to ensure employee safety. Option A is incorrect because dismissing a complaint could be considered retaliation and a violation of OSHA. Option B is incorrect because the National Labour Relations Board deals with union-related issues, not workplace safety investigations. Option D is incorrect because there is no specific 60-day timeline for an internal investigation. Employers are expected to address hazards in a timely manner. 26. Which law governs the use of consumer reports in employment decisions, including credit checks and background checks? A. Employee Retirement Income Security Act. B. Fair Credit Reporting Act. C. National Labour Relations Act. D. Equal Pay Act. Do you know the answer? Correct answer, B. Fair Credit Reporting Act. Explanation. Option B is correct because the Fair Credit Reporting Act, or FCRA, is the federal law that promotes accuracy, fairness and privacy for the information in consumer reporting agency files, and it dictates how employers can obtain and use these reports for employment purposes. Option A is incorrect because the Employee Retirement Income Security Act regulates pension and welfare benefit plans. Option C is incorrect because the National Labour Relations Act governs union and management relations. Option D is incorrect because the Equal Pay Act prohibits wage discrimination based on sex. 27. Under which federal law are employees entitled to job-protected, unpaid leave for certain family and medical reasons? A. Family and Medical Leave Act. B. Americans with Disabilities Act. C. Fair Labor Standards Act. D. Worker Adjustment and Retraining Notification Act. Can you guess the answer? Correct answer, A. Family and Medical Leave Act. Explanation. Option A is correct because the Family and Medical Leave Act, or FMLA, provides eligible employees of covered employers with up to 12 weeks of unpaid, job-protected leave per year for specified family and medical reasons. Option B is incorrect because the Americans with Disabilities Act requires reasonable accommodations for disabilities, but does not provide a general entitlement to extended leave for family reasons. Option C is incorrect, because the Fair Labour Standards Act sets standards for minimum wage and overtime pay. Option D is incorrect because the Worker Adjustment and Retraining Notification Act requires notice of mass layoffs, not leave entitlements. 28. Which act requires employers to pay employees equally for performing jobs that require equal skill, effort, and responsibility? A. Fair Labour Standards Act. B. Equal Pay Act. C. Worker Adjustment and Retraining Notification Act. D. Americans with Disabilities Act. Do you know the answer? Correct answer: B. Equal Pay Act. Explanation. Option B is correct because the Equal Pay Act of 1963 is a labour law that amended the Fair Labour Standards Act, aimed at abolishing wage disparity based on sex. It requires equal pay for men and women doing substantially equal work. Option A is incorrect because while the Equal Pay Act is technically an amendment to the FLSA, the FLSA's primary focus is on minimum wage and overtime, not equal pay for equal work. Option C is incorrect because the Worker Adjustment and Retraining Notification Act deals with plant closings and mass layoffs. Option D is incorrect because the Americans with Disabilities Act prohibits discrimination based on disability. (29) Which term refers to an employer's temporary work stoppage during a labour dispute, initiated to prevent employees from working? A. Strike. B. Lockout. C. Secondary boycott. D. Wildcat strike. Do you know the answer? Correct answer: B. Lockout. Explanation. Option B is correct because a lockout is a work stoppage or denial of employment initiated by the management of a company during a labour dispute. It is the employer's equivalent of a strike. Option A is incorrect because a strike is a work stoppage initiated by employees, not the employer. Option C is incorrect because a secondary boycott involves pressuring a neutral third-party employer, not a work stoppage at the primary employer's site. Option D is incorrect because a wildcat strike is a strike initiated by employees without the authorization of their union. 30. Which of the following laws requires an employer to provide reasonable accommodations for employees with disabilities? A. Fair Labour Standards Act. B. Americans with Disabilities Act. C. Family and Medical Leave Act. D. Equal Pay Act. What do you think is the answer? Correct answer: B. Americans with Disabilities Act. Explanation. Option B is correct because the Americans with Disabilities Act, or ADA, prohibits discrimination against qualified individuals with disabilities and requires covered employers to provide reasonable accommodations for them, unless doing so would cause undue hardship. Option A is incorrect because the Fair Labour Standards Act regulates wages and hours. Option C is incorrect because the Family and Medical Leave Act provides for unpaid job-protected leave for certain family and medical reasons. Option D is incorrect because the Equal Pay Act addresses wage discrimination based on sex. 31. What does the term underutilisation refer to in the context of an affirmative action plan? A. The hiring of fewer workers than needed. B. A shortage of minority employees in a specific job category. C. The use of temporary workers instead of full-time employees. D. The failure to meet production targets. Can you guess the answer? Correct answer: B. A shortage of minority employees in a specific job category. Explanation. Option B is correct because in the context of affirmative action, underutilization is defined as having fewer minorities or women in a particular job group than would reasonably be expected by their availability in the relevant labour markets. Option A is incorrect because underutilization refers to the demographic composition of the workforce, not the total number of employees relative to operational needs. Option C is incorrect because the use of temporary workers relates to staffing strategy, not the specific demographic analysis required for affirmative action. Option D is incorrect because failing to meet production targets is an operational issue, not a term related to workforce demographics in affirmative action. (32) What is the primary purpose of the Family and Medical Leave Act? A. To provide workers with paid time off for personal reasons. B. To allow employees to take unpaid, job-protected leave for family or medical reasons. C. To regulate employer-provided health insurance. D. To mandate employer-sponsored retirement benefits. Do you know the answer? Correct answer, B. To allow employees to take unpaid, job-protected leave for family or medical reasons. Explanation. Option B is correct because the central provision of the Family and Medical Leave Act, or FMLA, is to grant eligible employees up to 12 weeks of unpaid, job-protected leave for reasons such as the birth of a child, a serious health condition, or caring for a family member with a serious health condition. Option A is incorrect because FMLA leave is generally unpaid, although an employee may elect, or an employer may require the employee, to use accrued paid leave. Option C is incorrect because regulation of health insurance is primarily handled by laws like COBRA and the Affordable Care Act. Option D is incorrect because retirement benefits are primarily regulated by the Employee Retirement Income Security Act. (33) What is the primary focus of the Occupational Safety and Health Act? A. To regulate minimum wage and overtime pay. B. To ensure safe and healthy working conditions for employees. C. To provide employees with health benefits. D. To protect employees from discrimination based on age or disability. What do you think is the answer? Correct answer, B. To ensure safe and healthy working conditions for employees. Explanation. Option B is correct because the Occupational Safety and Health Act, or OSHA, was created to assure safe and healthful working conditions for working men and women by setting and enforcing standards and by providing training, outreach, education, and assistance. Option A is incorrect because regulating wages and overtime is the function of the Fair Labour Standards Act. Option C is incorrect because OSHA does not mandate health benefits. It mandates a safe work environment. Option D is incorrect because protecting employees from age or disability discrimination is the focus of the Age Discrimination in Employment Act and the Americans with Disabilities Act, respectively. (34) Which act requires employers to offer continued health insurance benefits after an employee has been terminated or has voluntarily left employment? A. Worker Adjustment and Retraining Notification Act. B. Consolidated Omnibus Budget Reconciliation Act. C. Family and Medical Leave Act. D. Equal Pay Act. Can you guess the answer? Correct answer, B. Consolidated Omnibus Budget Reconciliation Act. Explanation. Option B is correct because the Consolidated Omnibus Budget Reconciliation Act, commonly known as COBRA, gives workers who lose their health benefits the right to choose to continue group health benefits provided by their group health plan for limited periods of time after job loss. Option A is incorrect because the Worker Adjustment and Retraining Notification Act requires employers to provide advance notice of mass layoffs. Option C is incorrect because the Family and Medical Leave Act provides for job-protected leave, not post-employment benefits. Option D is incorrect because the Equal Pay Act addresses wage discrimination based on sex. 35. What is the primary function of the Equal Employment Opportunity Commission? A. To regulate employee retirement benefits. B. To enforce federal anti-discrimination laws in the workplace. C. To oversee collective bargaining agreements. D. To implement wage and hour regulations. Do you know the answer? Correct answer, B. To enforce federal anti-discrimination laws in the workplace. Explanation: Option B is correct because the Equal Employment Opportunity Commission, or EOC, is the federal agency responsible for enforcing federal laws that make it illegal to discriminate against a job applicant or an employee because of the person's race, colour, religion, sex, national origin, age, disability, or genetic information. Option A is incorrect because regulating retirement benefits is primarily handled by the Department of Labour and the Pension Benefit Guaranty Corporation under ERISA. Option C is incorrect because overseeing collective bargaining is the primary role of the National Labour Relations Board. Option D is incorrect because implementing wage and hour regulations is the responsibility of the Wage and Hour Division of the Department of Labour. (36) Which of the following is required for a workplace to be considered as having a hostile work environment under Title VII? A. Occasional offhand comments about race or gender. B. A single incident of offensive behaviour. C. A pattern of unwelcome conduct that is severe or pervasive enough to create an intimidating or abusive work environment. D. Any disagreement between an employee and a supervisor. Do you know the answer? Correct answer, C. A pattern of unwelcome conduct that is severe or pervasive enough to create an intimidating or abusive work environment. Explanation: Option C is correct because to be legally actionable as a hostile work environment, the conduct must be so severe or pervasive that it creates a work environment that a reasonable person would consider intimidating, hostile, or abusive. Option A is incorrect because isolated incidents such as occasional offhand comments are usually not sufficient to meet the legal standard of severe or pervasive. Option B is incorrect because while a single incident can be severe enough to create a hostile environment, if it is exceptionally egregious, the standard generally requires a pattern of behaviour. Option D is incorrect because simple disagreements or personality conflicts that are not based on a protected characteristic do not constitute a hostile work environment. 37. What does the Sherman Antitrust Act aim to prevent? A. Monopolies and anti-competitive practices. B. Unfair labour practices. C. Child labour. D. Age discrimination in employment. Do you know the answer? Correct answer, A. Monopolies and anti-competitive practices. Explanation: Option A is correct because the Sherman Antitrust Act of 1890 is a landmark federal statute that outlaws monopolistic business practices and conspiracies that unreasonably restrain trade. Option B is incorrect because unfair labour practices related to unions are addressed by the National Labour Relations Act. Option C is incorrect because child labour is regulated by the Fair Labour Standards Act. Option D is incorrect because age discrimination is prohibited by the Age Discrimination in Employment Act. (38) Which act ensures that employees can return to their civilian jobs after serving in the military? A. Family and Medical Leave Act. B. Worker Adjustment and Retraining Notification Act. C. Uniformed Services Employment and Re-employment Rights Act. D. Consolidated Omnibus Budget Reconciliation Act. What do you think is the answer? Correct answer, C. Uniformed Services Employment and Re-employment Rights Act. Explanation. Option C is correct because the Uniformed Services Employment and Re-employment Rights Act, or USERRA, protects the job rights of individuals who voluntarily or involuntarily leave employment positions to undertake military service. It ensures they can return to their jobs with the same seniority, status and pay. Option A is incorrect because the Family and Medical Leave Act provides for leave for family and medical reasons, not military service re-employment. Option B is incorrect because the Worker Adjustment and Retraining Notification Act pertains to notice for mass layoffs. Option D is incorrect because the Consolidated Omnibus Budget Reconciliation Act deals with the continuation of health coverage. (39) Which term refers to the concept that both parties in a contract will act in good faith and fairness? A. Fiduciary duty. B. Covenant of good faith and fair dealing. C. Disparate impact. D. Implied contract. What do you think is the answer? Correct answer, B. Covenant of good faith and fair dealing. Explanation. Option B is correct because the implied covenant of good faith and fair dealing is a general presumption that the parties to a contract will deal with each other honestly, fairly, and in good faith, so as not to destroy the right of the other party to receive the benefits of the contract. Option A is incorrect because a fiduciary duty is a higher standard of care owed by one party to another, such as a trustee to a beneficiary, and is not inherent in all contracts. Option C is incorrect because disparate impact is a legal term in discrimination law for a policy that appears neutral but has a discriminatory effect. Option D is incorrect because an implied contract is a contract that is not written but is inferred from the actions or conduct of the parties. 40. Which of the following laws allows employees to take intermittent leave rather than continuous leave for certain family or medical reasons? A. Fair Labour Standards Act. B. Worker Adjustment and Retraining Notification Act. C. Family and Medical Leave Act. D. Consolidated Omnibus Budget Reconciliation Act. What do you think is the answer? Correct answer, C. Family and Medical Leave Act. Explanation. Option C is correct because the Family and Medical Leave Act, or FMLA, provides that employees may take leave on an intermittent basis or on a reduced leave schedule when medically necessary, such as for planned medical treatments or for a chronic serious health condition. Option A is incorrect because the Fair Labour Standards Act deals with wage and hour regulations, not leave schedules. Option B is incorrect because the Worker Adjustment and Retraining Notification Act requires notice of mass layoffs. Option D is incorrect because the Consolidated Omnibus Budget Reconciliation Act provides for the continuation of health benefits after employment ends. (41) What is required under the Pregnancy Discrimination Act regarding pregnancy-related health coverage? A. Employers can exclude pregnancy coverage from health insurance. B. Employers must treat pregnancy as any other medical condition under health insurance policies. C. Employers must provide paid leave for pregnant employees. D. Employers can require pregnant employees to take unpaid leave. What do you think is the answer? Correct answer. B. Employers must treat pregnancy as any other medical condition under health insurance policies. Explanation. Option B is correct because the Pregnancy Discrimination Act mandates that if an employer provides health insurance, it must cover expenses for pregnancy-related conditions on the same basis as costs for other medical conditions. Option A is incorrect because excluding pregnancy coverage while covering other medical conditions is a violation of the Act. Option C is incorrect because the Act does not mandate paid leave. It only requires that if paid leave is offered for other medical conditions, it must also be offered for pregnancy. Option D is incorrect because an employer cannot force a pregnant employee to take leave if she is still able to perform her job duties. 42. Which Act requires employers to make reasonable accommodations for veterans returning from military service? A. Family and Medical Leave Act. B. Uniformed Services Employment and Re-employment Rights Act. C. Worker Adjustment and Retraining Notification Act. D. Equal Pay Act. What do you think is the answer? Correct answer. B. Uniformed Services Employment and Re-employment Rights Act. Explanation. Option B is correct because the Uniformed Services Employment and Re-employment Rights Act, or USERRA, requires employers to make reasonable efforts to accommodate veterans with disabilities incurred or aggravated during military service. Option A is incorrect because the Family and Medical Leave Act provides for leave but is not specific to accommodations for veterans. Option C is incorrect because the Worker Adjustment and Retraining Notification Act deals with notice for mass layoffs. Option D is incorrect because the Equal Pay Act addresses wage discrimination based on sex. (43) Which law prohibits the discrimination of employees based on pregnancy, childbirth, or related medical conditions? A. Family and Medical Leave Act. B. Pregnancy Discrimination Act. C. Fair Labour Standards Act. D. Equal Pay Act. What do you think is the answer? Correct answer. B. Pregnancy Discrimination Act. Explanation. Option B is correct because the Pregnancy Discrimination Act is a federal law that amended Title VII of the Civil Rights Act to explicitly prohibit employment discrimination on the basis of pregnancy, childbirth, or related medical conditions. Option A is incorrect because the Family and Medical Leave Act provides for job-protected leave for childbirth but does not cover all forms of pregnancy-related discrimination. Option C is incorrect because the Fair Labour Standards Act establishes minimum wage and overtime standards. Option D is incorrect because the Equal Pay Act prohibits wage discrimination based on sex. 44. What does the term quid pro quo refer to in a sexual harassment context? A. Hostile work environment created by unwanted conduct. B. Sexual favours demanded in exchange for employment benefits. C. Equal treatment of employees. D. Unwanted comments or jokes based on gender. Can you guess the answer? Correct answer. B. Sexual favours demanded in exchange for employment benefits. Explanation. Option B is correct because quid pro quo, which is Latin for this for that, is a type of sexual harassment where a person in a position of authority demands sexual favours from a subordinate in exchange for a job benefit like a promotion, raise, or continued employment. Option A is incorrect because this describes hostile work environment harassment, which is the other main type of sexual harassment. Option C is incorrect because quid pro quo is the opposite of equal treatment. It involves unequal and illegal treatment. Option D is incorrect because unwanted comments or jokes are examples of conduct that could create a hostile work environment, but they are not quid pro quo. 𝗬𝗢𝗨𝗥. Under the Americans with Disabilities Act, when can an employer decline to hire an individual with a disability? A. When the individual's condition poses a direct threat to the safety of others. B. When the individual is unable to work full-time. C. When the employer believes the employee will need excessive time off. D. When the individual requires any accommodation to perform the job. Can you guess the answer? Correct answer, A. When the individual's condition poses a direct threat to the safety of others. Explanation. Option A is correct, because the Americans with Disabilities Act, or ADA, allows an employer to establish a qualification standard that an individual shall not pose a direct threat to the health or safety of themselves or others in the workplace, and no reasonable accommodation can eliminate or reduce this threat. Option B is incorrect because an inability to work full-time may be a disability that requires an accommodation, such as a part-time schedule, which the employer must consider. Option C is incorrect because an employer's belief or speculation about future time off is not a valid reason to deny employment. Option D is incorrect because the ADA explicitly requires employers to provide reasonable accommodations, so the need for one is not a basis for refusing to hire a qualified applicant. 46. Which of the following terms refers to the temporary suspension of employment initiated by an employer during a labour dispute? A. Lockout. B. Strike. C. Layoff. D. Economic strike. Can you guess the answer? Correct answer, A. Lockout. Explanation. Option A is correct because a lockout is a management-initiated work stoppage during a labour dispute where the employer prevents employees from working. Option B is incorrect because a strike is a work stoppage initiated by employees. Option C is incorrect because a layoff is a termination of employment, which can be temporary or permanent, typically due to business reasons like a lack of work, not as a tactic in a labour dispute. Option D is incorrect because an economic strike is a type of strike initiated by employees over economic issues like wages, not an action taken by an employer. 𝗬𝗢𝗨. Which of the following describes an employer's defence to a disparate impact claim, asserting that the policy or practice in question is related to the job and is consistent with business necessity? A. Reasonable accommodation. B. Business necessity defence. C. Bona fide occupational qualification. D. Undue hardship. Do you know the answer? Correct answer, B. Business necessity defence. Explanation. Option B is correct because the business necessity defence is used by an employer to justify an employment policy or practice that has a discriminatory effect on a protected class. The employer must prove the practice is job-related and essential for the business's operation. Option A is incorrect because reasonable accommodation is an employer's obligation to adjust a job or work environment for an individual with a disability or religious belief. Option C is incorrect because a bona fide occupational qualification is a defence for intentional discrimination or disparate treatment, not for disparate impact claims. Option D is incorrect because undue hardship is a defence an employer can use to show that providing a reasonable accommodation would be too difficult or expensive. 𝗬𝗢𝗨𝗥. Which term refers to a bargaining subject that neither party is required to negotiate over in a collective bargaining agreement? A. Permissive bargaining subject. B. Mandatory bargaining subject. C. Unfair labour practice. D. Economic strike subject. Can you guess the answer? Correct answer. A. Permissive bargaining subject. Explanation. Option A is correct because a permissive subject of bargaining is one that is not related to wages, hours, and other terms and conditions of employment. Parties may voluntarily bargain over these subjects, but it is not illegal for a party to refuse to do so. Option B is incorrect because a mandatory bargaining subject, such as wages or hours, is a topic that both the union and management are legally required to negotiate over in good faith. Option C is incorrect because an unfair labour practice is a violation of labour law, not a category of bargaining subjects. Option D is incorrect because economic strike subject is not a standard legal term for a category of bargaining topics. (49) Which federal law requires employers to provide employees with time off to care for a newborn or newly adopted child? A. Worker Adjustment and Retraining Notification Act. B. Family and Medical Leave Act. C. Fair Labor Standards Act. D. Americans with Disabilities Act. Can you guess the answer? Correct answer. B. Family and Medical Leave Act. Explanation. Option B is correct because the Family and Medical Leave Act, or FMLA, allows eligible employees to take up to 12 weeks of unpaid, job-protected leave for the birth and care of a newborn child, or for the placement of a child for adoption or foster care. Option A is incorrect because the Worker Adjustment and Retraining Notification Act deals with notice requirements for mass layoffs. Option C is incorrect because the Fair Labor Standards Act sets standards for wages and overtime pay. Option D is incorrect because the Americans with Disabilities Act focuses on preventing discrimination against individuals with disabilities. 50. Which act ensures that an employee can sue for damages if they face discrimination based on race, gender, or religion in the workplace? A. Fair Labor Standards Act. B. Americans with Disabilities Act. C. Title VII of the Civil Rights Act of 1964. D. Family and Medical Leave Act. Do you know the answer? Correct answer. C. Title VII of the Civil Rights Act of 1964. Explanation. Option C is correct, because Title VII of the Civil Rights Act of 1964 is a federal law that prohibits employers from discriminating against employees on the basis of sex, race, colour, national origin, and religion. It provides the legal foundation for employees to sue for damages resulting from such discrimination. Option A is incorrect because the Fair Labor Standards Act provides remedies for violations of wage and hour laws, not discrimination. Option B is incorrect because the Americans with Disabilities Act allows for lawsuits based on disability discrimination, but not race, gender, or religion. Option D is incorrect because the Family and Medical Leave Act allows for lawsuits related to the denial of leave rights, not general workplace discrimination. You have reached the end of our first question set. For the free complete exam preparation, visit our website link in the description, where you find thousands more practice questions and comprehensive study guides. Thanks for studying with us today. See you in the next video.